Yak Got It and Young Thug each filed motions to recuse Chief Judge Glanville from this case. In support of their motions, each defendant submitted an affidavit or affidavits. The recusal motion was assigned to Judge Rachel Krause. On July 17, 2024, Judge Krause ruled on the motions and entered an order containing written findings of fact and conclusions. So the state has finally responded to all of these motions that have been brought forward in the last 24 hours. It's going absolutely crazy, and the state is not holding back in their responses. We're going to go through these and read these real quick. Y'all let me know what you think in the comments. If this was a good response by them, the first thing we're going to go over is a notice from the state. All right. We've got the state of Georgia versus Young Thug. It's a letter to Judge Whitaker. Notice: the state hereby notices the defendants in this case and this honorable court of the following. It has come to the state's attention that on May 2nd, 2015, the honorable court issued an order of recusal with regards to a motion for a new trial. All right. The fact underlying, the prior case are related to the present case and are not a part of this case. The prior case involved the December 22nd, 2007 murder of James Yarborough. The present case involves allegations of criminal activity by and through members of YSL, which formed years later in 2012. On information belief, the recusal order was based upon the court's prior supervisory role over the appellate unit of the district attorney's office during the presidency of Greer's motion for a new trial. That order might even have been issued in error, as the amended motion for a new trial Mr. Steele filed on Greer's behalf on December 2016, before the order of recusal already listed the same judicial officer who ultimately resolved Greer's motion for a new trial in 2019. Now, what in the world are they saying? We're going to get into it here in a second. Although Greer was a confidant in the present case, Greer pleaded guilty in the present case in November 23. The state provides this notice simply as a point of information. Now, y'all are probably wondering, who in the world is this Greer dude? Well, this is someone who is related to Young Thug. He goes by the rapper name Unfunk. All right. And he was represented by Brian Steele. Now, with the state pointing this out, they're trying to show that, hey, there might be something there. There might be some type of conflict, and you guys need to keep that in mind as we go throughout the trial. And I highly doubt that this is the last time we're going to hear about Quintavious Greer or the fact that Brian Steele represented him. So now we go back to the state's response to everything that went down today, right? And that went down yesterday. And they filed this at 11:21 p.m. They filed this at night. Check this out. State's response in opposition to defendants Williams' motion to challenge factual findings. Following the recusal of Chief Judge Glanville, precipitated by the motions of defendants Young Thug and Yak Got It, defendants Young Thug has filed a motion to challenge the factual findings made by Judge Krause in her order recusing Judge Glanville. All right, for the reasons cited below, the state respectfully moves this court to deny the relief of Young Thug's motion request. In support of this motion, the state shows the honorable court as follows. Now, if y'all are wondering about the motion to challenge factual findings, we talked about it in another video and we went through it. And Brian Steele was basically saying that, hey, Judge Krause, when she ruled, although she said she was throwing Judge Glanville out, she also said that he didn't do anything wrong. And Brian Steele said, and I completely and 100% disagree. And again, this is from Thugger Daily. And we went over that in another video. Y'all can go back and check that out. But what the state is saying here is that Brian Steele was wrong and there's an issue. Let's get some background. Yak Got It and Young Thug each filed motions to recuse Chief Judge Glanville from this case. In support of their motions, each defendant submitted an affidavit or affidavits. The recusal motion was assigned to Judge Rachel Krause. On July 17, 2024, Judge Krause ruled on the motions and entered an order containing written findings of fact and conclusions. as required by Uniform Superior Court Rule 25.6. Legal authority and application of the law by Judge Krause. Basically, she did her job here. She considered the motions to recuse solely on the affidavit submitted by the defendants. And as required by law, Judge Krause included in her recusal order written findings of fact and conclusions as mandated by Rule 25.6. Even when the motion to recuse has no merit, if a judge is perceived as refuting a charge is refusing a charge of bias, the judge's actions create a basis for recusal. That's why I was messing this up. I kept seeing basis. My bad, y'all. Let me read this one more time. Even when a motion to recuse has no merit, if a judge is perceived as refuting a charge of bias, the judge's actions create a basis for recusal. Judge Krause wrote that, and we talked about this again, so we're not going to read through that, but basically transferring the case to another judge for consideration, Glanville necessarily determined that the recusal didn't need to happen. Judge Krause agreed generally with Judge Glanville's assessment of the propriety of the ex parte meetings, but found that Judge Glanville created a basis for his recusal when he added facts, provided context, questioned the veracity of allegations, and otherwise explained his decisions and actions and argued why those actions were proper. Judge Krause found that in presenting his record as to recusal issues and ruling on Yak Goddess motion, Judge Glanville evaluated and accepted the truth of his own factual allegations, mandating his recusal, which is why he's up out of there. First Young Thug objects to the order reference to his recusal motion, inclusion of hyperbole. The reference to hyperbole is accurate. More importantly, the reference to hyperbole is not itself a factual finding and is not a material issue for litigation. Second, Young Thug asserts that Judge Krause finding that the hearing in chambers was not proper is wholly against the law. That assertion is clearly incorrect. The hearing in chambers was regarding a witness immunity and compelled testimony. Such a hearing without the defense present has been held to be proper by the Supreme Court of Georgia, which ruled the defense has no standing to be present at such hearings. Nah, we're not buying it.
Stop the cap.
They should have been there. Let's stop it. For the reasons stated above, the state moves this honorable court to deny defendant Young Thug's motion to challenge factual findings. Respectfully submitted, 23rd day, July 2024, Adrian Love. Sorry, I pressed the wrong sound effect. So y'all gotta let me know what you think about that one. This is very interesting that they're going back and forth and really fighting this issue. As I mentioned in the previous video, when we talked about Brian Steele's motion challenging the factual findings, I think this was a chess move by him. And this is another chess move by the prosecution because they can probably see, as we mentioned in the last video, where he's going with this. So y'all let me know what you think in the comments and in the chat.